Every public company needs a team to handle the Reg FD issues that come up on nearly a daily basis. Typically, this team is comprised of those on the disclosure committee or a subset. This could be someone from the legal department, the securities lawyer if there is one, and maybe the general counsel, someone from the IR department, corporate communications perhaps, the finance department, and sometimes conferring with outside counsel for sticky issues. The disclosure team will need to handle both intentional and unintentional situations, either violations or matters to prevent there from being a violation, and be aware of the high knowing or reckless standard that the SEC baked into Rule 101A of Reg FD. This is the definition of intentional. Note that the person making the disclosure must know or be reckless in not knowing that the information they've provided is both material and non-public. The SEC was careful that a mistaken materiality judgment would not result in enforcement action. So if a company acts in good faith, it is very unlikely that they will be found to be reckless. The definition of materiality for Reg FD is the same as it is for other issues. Reg FD doesn't provide a special definition. So this is the standard that security lawyers know very well, the TSC Industries versus Northway, the 1976 Supreme Court decision as refined in Basic v. Levinson by Supreme Court in 1988. Materiality is if there's a substantial likelihood that a reasonable investor would consider it important in making an investment decision. Thus, this standard looks at the reasonable investor, not the actual recipient of the disclosure. But of course, regulators are acting in hindsight and looking at what happened. Hindsight is 2020. Note that the SEC in 2002 issued a Section 21A report. This is an enforcement report that gives guidance to the entire market. This dealt with Motorola, a company which got credit for honestly and carefully considering their attempts to comply with Reg FD. So this report came out just 2 years after Reg FD was adopted and gave further guidance. Reg FD's adopting release in 2000 contains a non-exclusive list of matters for companies to consider. This is one of the few attempts that the SEC got close to weighing in on what is material. So these enumerated matters in the adopting release warrant careful review and should be presumed to be material. Clearly, anything earnings related should always be considered material. Note that there's a difference between intentional versus unintentional selective disclosures. If a company is planning to make a selective disclosure, such as at an investor conference, it needs to be prepared to make that same information widely available simultaneously as at the investor conference. Typically this is done filing a Form 8K, or they could find another method that is designed to provide a broad and non-exclusionary distribution of that information. An unintentional selective disclosure, so this is a mistake that someone makes within an authorized spokesperson makes, requires public disclosure promptly. The disclosure team will need to get together and put together an 8K and get that on file fast.